Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. If you're enjoying this legal education content, please remember to subscribe. It helps the channel grow. For today's case, we're doing a 2017 U.S. Supreme Court case about proper restrictions on prurient offenders. This is the case of Packingham versus North Carolina. In this case, Mr. Packingham had been convicted of certain prurient offenses, and he was prevented from accessing the internet in certain ways. The U.S. Supreme Court has to figure out whether or not these restrictions are proper or whether or not they violate the First Amendment. Let's get started with this. North Carolina law makes it a felony for a registered prurient offender to access a commercial social networking website when the prurient offender knows the site permits minor children to become members of or maintain a personal web page. The statute includes two express exemptions. The statutory bar does not extend to websites that provide only one of the following discrete services: photo sharing, electronic mail, instant messenger, or chat room or message board platforms, which seems like a slightly odd carve-out to my mind, because you want, or at least are not willing to forbid prurient offenders from having access to message boards or chat rooms in particular. Seems like a slightly strange carve-out to my mind, but apparently the state of North Carolina thought this made sense. So we'll go with that. The law also does not encompass websites that have as their primary purpose the facilitation of commercial transactions, including goods or services, between members and visitors. So I guess that's good, and there's some restrictions and some things that don't apply, okay? In 2002, the petitioner, Lester Gerard Packingham, then a 21-year-old college student, had relationship with a 13-year-old, which is not necessarily ideal. He pled guilty to taking some liberties with a child. Apparently that's the actual offense here. Okay, all right. Because this crime qualifies as an offense against a minor, the petitioner is required to register as a prurient offender, a status that can endure for 30 years or more. So in 2002, he had this lapse of judgment, I guess. And, he pled guilty to that, and he's required to maintain a particular status, and the status may inhibit his abilities online. Okie doke. So in 2010, a state court dismissed a traffic ticket against the petitioner. In response, he logged onto Facebook.com, and he posted the following statement on his personal profile. "Man, God is good. How I got so much favor they dismissed the ticket before it even started. No fine, no court costs, nothing spent. Praise be to God. Wow, thanks Jesus." Well, I guess when God closes a door, God opens a window or something, because he just posted this on Facebook, which may be a site which allows minors to maintain personal pages. So, yeah, he might have gotten out of his traffic ticket, but things are going to get a little bit more interesting for our friend over here. Petitioner was indicted by a grand jury for violating the law. The trial court denied his motion to dismiss the indictment on the grounds that the charge against him violated the First Amendment. Petitioner was ultimately convicted and given a suspended prison sentence. At no point during the trial or sentencing did the state allege that petitioner contacted a minor or committed any other illicit act. So he is merely being charged with violating the law for merely posting on Facebook because it's a site that allows minors to create profiles. And that's a violation of this law. So he pled guilty to that, and he'd like to protest that, that is improper under the First Amendment. A fundamental principle of the First Amendment is that all persons have access to places where they can speak and listen, and then after reflection speak and listen once more, which the internet is known very well for, the listening part in particular. The court has sought to protect the rights to speak in the spatial context. While in the past it may have been difficult in identifying the most important places in a spatial sense for the exchange of views, today the answer is clear: cyberspace. The vast democratic forms of the internet in general and social media in particular. So the Supreme Court is recognizing that, where the most important place, I suppose, in a practical sense, to express one's views in older times might have been a little bit harder. Was it a city hall? Was it a park? Was it a university? Whatever. But the Supreme Court says, in the modern era, this is a little bit easier. It's definitely cyberspace. That is the place where the facilitation of speech and also listening, apparently, is happening most. So it is the new town square to put it in old parlance. This case is one of the first the court has taken to address the relationship between the First Amendment and the modern internet. As a result, the court must exercise extreme caution before suggesting the First Amendment provides scant protection for access to the vast networks in the medium. By prohibiting prurient offenders from using these websites, North Carolina, with one broad strokes, bars access to what for many are a principal source for knowing current events, checking ads for employment, speaking and listening in the modern public square, and otherwise exploring the vast realms of human thought and knowledge. These websites can provide perhaps the most powerful mechanism available to a private citizen to make his or her voice heard. Thus allows a person with internet connection to become a town crier, with a voice that resonates farther than it could from any soapbox. The primary response from the state is the law must be this broad to serve its preventative purpose of keeping convicted prurient offenders away from vulnerable victims. The state has not, however, met its burden to show the sweeping law is necessary or legitimate to serve this particular purpose. So here the Supreme Court is pointing out that when you are restricting freedom of speech in any context, you must make sure that the restrictions are not greater than they have to be for the particular reason. And the North Carolina statute, the Supreme Court is ruling, is overly broad the way it's written. That doesn't say, of course, that they couldn't write a more narrow version that would prohibit the kind of contact they're more looking for, but it is saying that it's over-sweeping in its breadth, because by preventing people from signing up for all these different websites where anyone could establish a profile, it prevents people from getting access to vast quantities of information, even if there's some underlying purpose. So the Supreme Court is saying that here the way the regulation was written is just overbroad, and the state has to go back and draw it a little bit more narrowly tailored to the particular need that they have. It is well established that, as a general rule, the government may not suppress lawful speech as a means to suppress unlawful speech. That is what North Carolina has done here. Its law, therefore, as written, must be held to be invalid. Thus, that brings us to the end of the case of Packingham versus North Carolina, in which the Supreme Court is asked for the first time to consider the scope of restrictions of people convicted of certain crimes from accessing the internet. And the Supreme Court points out that access to the First Amendment is of value even to the convicted criminal. Now, of course, the convicted criminal in this particular context in specific may be of a particular threat to young people. And so the courts say very clearly that they can impose restrictions that would prohibit certain kinds of contact or certain kinds of things. It just has to be a little bit more narrow. So what North Carolina did is made a more blanket prohibition that blocked large swaths of the internet for people who are convicted of this various offenses, even people who had served their time for the conviction. So this was overly broad as written, and that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye. Daniela says a relationship ? Yeah, I'm assuming I said relationship. And Daniela, the reason I said relationship is because I'm trying to skirt around particular language because of YouTube and the algorithm. It's not because I ideally would like to call it a relationship. It's just that I'm trying to avoid certain word choices. So you'll forgive me if I called it a relationship. It wasn't really, strictly speaking, my decision. It's because YouTube, and YouTube hates it when we cover certain topics. So what else do you want from me? Sorry about that, but the algorithm. The algorithm is almighty. I don't want my channel to be banned. We do what we have to over here. Sorry about that.